COVID-19 has been around since at least March of 2020, and it seems that it will be around for a little while longer. Fortunately, we have effective vaccines, which means more people can survive COVID-19. But with that, more likely there will be long haulers. That is, people who will have long-lasting effects of COVID-19 or long COVID. As explained by the Centers for Disease Control, although many people with COVID-19 get better within weeks, some people continue to experience symptoms that can last months after first being infected, or they may have new or recurring symptoms at a later time. The CDC has specifically stated that, quote, post-COVID-19 conditions are a wide range of new, returning, or ongoing health problems people can experience 4 or more weeks after being first infected with a virus that causes COVID-19, close quote. These conditions can happen to anyone who has COVID-19, even if the initial illness was mild. Interestingly, even originally asymptomatic patients can have post-COVID-19 conditions. Next slide, please, Mary. Long COVID is also known as post-acute COVID-19, the long-term effects of COVID, or chronic COVID. According to recent research, more than 11 million people nationwide are living with long COVID, and that between 10% and 30% of those infected with the coronavirus will suffer from long COVID. It's really not clear how long COVID lasts. It really varies for each person. Some people will fully recover in just a few months. Others may continue suffering the symptoms of long COVID, even if their infection took place over 12 months ago. People commonly report experiencing different combinations of the following symptoms when it comes to long COVID: sleep problems, fever, joint or muscle pain, headache, chest or stomach pain, changes in smell or taste, difficulty thinking or concentrating, sometimes known as or referred as brain fog, tiredness or fatigue, difficulty breathing or shortness of breath. Unfortunately, the list is not exhaustive. Next slide, please. So the question is long COVID a disability under the Americans with Disabilities Act? Yes, the short answer is yes. Long COVID can be a disability under the ADA. Really, almost any physical or mental impairment that can substantially limit a major life activity will qualify as a disability under the ADA. So if you have a medical issue that affects either your physical body or your mind, it most likely would be eligible for ADA protections, so long as it substantially limits a major life activity. And I will address the more in-depth definition of a disability under the ADA in a later slide. Next slide, please, Mary. So on July 26th of this year, in light of the rise of long COVID as a significant health issue, the Department of Health and Human Services and the Civil Rights Department of the Department of Justice joined together to provide a joint guidance. This guidance contains an enormous amount of information regarding long COVID. The guidance explains that COVID can be a disability, long COVID can be a disability under Titles I and Titles II of the Americans with Disabilities Act and Section 504 of the Rehabilitations Act of 1973. Each of these federal laws protect people with disabilities from discrimination. Notably, the joint guidance really just focuses on long COVID. It did not address when COVID-19 may meet the legal definition of a disability. But ultimately, we have to determine whether we're dealing with COVID-19 or whether we're dealing with specifically long COVID-19. We still have to go through the same analysis of whether the condition at issue is a disability. Next slide, please. So the joint guidance states that while long COVID can be a disability, It is not always a disability. We really need to conduct an individualized assessment to determine whether a person's long COVID condition or any of its symptoms substantially limits a major life activity. The joint guidance, which I thought was really fascinating, provided examples under Titles 2 and 3 of the ADA of ways businesses or state or local governments will need to make changes to the way they operate to accommodate a person's long COVID-related limitations. There were quite a few examples. I will just give you a few. For example, providing additional time on a test for a student who has difficulty concentrating, or modifying a policy to allow a person who experiences dizziness when standing to be accompanied by their service animal that is trained to stabilize them. After the seminar, I'd be happy to provide you with the link to the joint guidance because I do think it provides a vast amount of information for us. The guidance does not address examples of reasonable accommodation or non-discrimination in employment under Title I of the ADA, but notably, the guidance does footnote that any employment issues related to COVID-19 are discussed in the technical assistance issued by the EEOC, which was just updated on October 25th. And again, we can provide you to the link of the EEOC's technical assistance after our webinar. Next slide, please. Interestingly, I did want to mention that on the EEOC's website, on September 9th of this year, the EEOC did issue a notice recognizing that long COVID may be a disability under the ADA in certain circumstances and agreed with the analysis in the joint guidance. Next slide, please, Mary. So we briefly touched upon the definition of a disability earlier, but more specifically, the ADA defines a person with a disability as an individual with a physical or mental impairment that substantially limits one or more of the major life activities of such individual, a person with a record of such an impairment, or a person who is regarded as having such an impairment. Thus, a person with long COVID has a disability if it meets the definition of a disability as just described. Next slide, please, Mary. So what is a physical impairment? A physical impairment includes any physiological disorder or condition affecting one or more body systems. In the guidance, it provides us with a few examples of what some people with long COVID experience. Those examples were lung damage, heart damage, including inflammation of the heart muscle, kidney damage, neurological damage, and damage to the circulatory system. It also indicates that a mental impairment includes any mental or psychological disorder, such as an emotional or mental illness. Next slide, please. What is a major activity? Well, that includes a wide range of activities, such as caring for oneself, performing manual tasks, concentrating, reading, thinking, writing, communicating, speaking, breathing. It's a very long list. The guidance notes that an impairment does not need to prevent or significantly or severely restrict the individual from performing a major life activity in order to be considered substantially limiting. It did note that impairments that only last for a short period of time are typically not covered, although they may be covered if sufficiently severe. Next slide, please. The joint guidance, again, provides specific examples of how long COVID might substantially limit a major life activity, and I'll review just a couple of those examples. One example that the joint guidance provides is a person with long COVID who has lung damage that causes shortness of breath and fatigue, or another, a person with long COVID who experiences memory lapses and brain fog is substantially limited in brain function, concentrating, and/or thinking. Next slide, please. I did want to touch upon just a few cases which address how courts are treating major life activities in the context of the ADA. The first case is Norman versus Langone Health Systems out of the Southern District of New York. And it was ruled upon in 2020. And while it's not specifically long COVID related, the analysis by the court can still be applied to long COVID conditions. And in this case, defendant had a policy mandating that all employees receive the flu vaccine, and those employees seeking an exemption had to submit a request form. Plaintiff characterized her disability as an allergy to the flu vaccine. She had two instances of this allergy to the flu vaccine, or negative reaction, that is. One she named was during childhood, and another time was in 2001, where she was vaccinated in nursing school and suffered an adverse reaction. She submitted an exemption request form by her doctor indicating that she had a previous reaction to the flu vaccine, and eventually she submitted to the flu vaccine to avoid being terminated from her employment. The plaintiff then brought an action alleging that her employer failed to accommodate her. She alleged disability discrimination as well. The court held that even assuming plaintiff's allergy to the flu vaccine constitutes an impairment that limits the major life activity of breathing, she had failed to show that this impairment substantially limited her breathing at the time she sought an accommodation. The court did note, however, and agreed that impairments that are either episodic or in remission can constitute a disability within the meaning of the Americans with Disabilities Act. Next slide, please, Mary. This case I found interesting. It was recently ruled upon in September of 2021, and it actually is specific to long COVID, and the court does cite the joint guidance which we discussed today. So this is the Matthias versus Terrapin House case, which is out of the Eastern District of Pennsylvania. And in this case, plaintiff alleged claims of disability discrimination, that her employer regarded her as having a disability, and that disability being COVID-19, and her employer believed that her disability, that disability substantially limited or impaired a major life activity. On the date that plaintiff informed her employer that she needed to take leave, disclosing that she received a positive COVID-19 test, disclosing that she was suffering from loss of smell and taste, her employer decided to terminate her employment, stating that she just wasn't a good fit. Okay, well, the employer argued that a mere diagnosis of COVID-19 did not substantially limit one or more major life activities, and therefore it did not qualify as a disability under the ADA. As I'm sure you're not surprised, the court rejected the employer's argument. It found that COVID-19 does not qualify as a that COVID-19 does qualify as a disability, at least in some circumstances. It actually relied on the joint guidance, which came out in July of 2021. And it explained that, quote, some people infected with COVID continue to experience symptoms that can last months after being infected, or may have new or recurring symptoms at a later time. The court did emphasize that an individual assessment is necessary to determine whether a person's long COVID condition or any of its symptoms substantially limits a major life activity in particular cases. This is an excellent segue into Alex's discussion of interactive process, reasonable accommodation, and undue hardship, and I will turn it over to Alex.
Thanks, Antoinette. So once you've decided that the particular employee that you're dealing with has a disability under the ADA, and you've made an assessment of their limitations as to their major life activities, you can then engage in the interactive process, which is the next step towards providing a reasonable accommodation. The interactive process is an informal discussion that you have to have with the employee to try and understand the scope of the employee's limitations, as well as the potential universe of ways that you can accommodate them. It's important to note that this obligation falls on both you as the employer as well as the employee. So that's why if an employee fails to submit medical documentation to support their request, or if you ask them to fill out an accommodation form and they fail to turn it in, then you can't be held liable for a failure to accommodate, because in that instance, the employee has caused a breakdown in the interactive process. And this interactive process is really a place where a lot of employers get tripped up, because it's more about the form and the process than it is about the result and the substance, as we'll see on the next slide with the Ruggiero case. This is a case out of the Third Circuit Court of Appeals in 2018. In this case, the plaintiff employee was a registered nurse at a hospital. She suffered from severe anxiety and esophagitis. The hospital that she worked at required all of its employees to get a Tdap vaccine, but this registered nurse refused to get the vaccine. She submitted a doctor's note that said that after she read the potential side effects of the Tdap vaccine, it triggered her anxiety, and she became terrified that she would get one of these potential side effects. So instead of getting the vaccine, she suggested to the hospital that she could just wear a mask all of the time while she was working. The hospital said, nope, that's not going to work. You're fired for not following the vaccine mandate. She filed a suit under the ADA, and the trial court dismissed the case. But on appeal, the Third Circuit reversed and found in favor of the employee. And the Third Circuit held that there was a plausible inference that the hospital failed to engage in the interactive process. Basically, she suggested an accommodation, either excuse me from the vaccine requirement or let me wear a mask. And the hospital, instead of having that required back and forth, just said, no, you have to engage in an interactive process. There has to be some form of a back and forth informal discussion. Otherwise, you're going to run afoul of the ADA. So regardless of what the accommodation request looks like, you have to engage in the interactive process. Next slide, please. And once you've engaged in that process, then you're in a position to ascertain whether the requested accommodation is reasonable or not. And specifically, when we're talking about employees who have long COVID, there's a number of potentially reasonable accommodations that we would expect to see requested. Things such as a leave of absence, depending on the length of time, could theoretically be reasonable. Perhaps a reduced work schedule. Maybe it's an employee who was hospitalized, has been discharged from the hospital and is regaining their strength, but still has some of the symptoms of long COVID. And maybe they can only work 2 or 3 days a week, or maybe they can only work 4 hours, but every day of the week. So perhaps some sort of alternate schedule. Potentially job restructuring could be a reasonable accommodation by removing non-essential duties from that employee and giving them to another employee. Potentially reassigning the employee to a different, less strenuous position if you have an opening for them. Or as we've all gotten used to in the COVID era, potentially a remote work arrangement could be a reasonable accommodation depending on the specifics of that employee's position. With that said, there are a number of things that you never need to do. You don't ever need to remove essential job functions as an accommodation. And the best way to know whether a job function is essential is to look at the job description. And that's a very good reason that you should always keep your job descriptions up to date and make sure that they accurately reflect the true essential functions of that job. So that way, if you're ever defending a claim of failure to accommodate and you want to say, no, we can't remove that job function, it's essential, you can just point directly to the job description and say, look, it's the first bullet point on your job description. We're sorry, but we can't remove that function. As you're considering accommodations, you never need to lower your performance or production standards, and you never need to provide accommodations that create undue hardships on you as the company. And that could be administratively, that could be a scheduling hardship, or it could be a financial hardship. Likewise, you never need to provide the employee's preferred accommodation. The law just says that you have to provide a reasonable accommodation. It doesn't necessarily need to be the one that the employee demands. And again, this is a really good reason to engage in the interactive process in good faith, because if you fully understand what the employee's limitations are, you're going to be in a better position to potentially suggest alternative accommodations that work better for you as a company. Next slide, please. So although we're talking about the ADA today, You should also keep in mind that someone with long COVID could potentially have rights under the Family and Medical Leave Act as well. And we're not going to get too deep into the weeds on this, but I just want to put it on your radar that you may have obligations under the FMLA. The ADA and the FMLA both generally deal with health issues, but they define those health issues very differently. As Antoinette said, a disability under the ADA has to do with a substantial impairment of a major life activity. Conversely, the FMLA deals with serious health conditions, which generally speaking are issues that require ongoing treatment or inpatient care. And the federal regulations say specifically, the ADA's disability and FMLA's serious health condition are different concepts and must be analyzed separately. So if you have an employee who is suffering from long COVID or requests an accommodation as a result of COVID or long COVID, you should immediately be thinking about performing a separate analysis under the FMLA as well. Next slide, please. So now that we've taken a high-level view of the ADA and how it applies to long COVID, there are a number of steps that you can preemptively take to minimize any type of legal claim. And the first thing is to go ahead and analyze the accommodations that we would expect to receive from sufferers of long COVID. We think those are going to be things like alternate scheduling arrangements, remote work, transferring job duties, things like that. You can go ahead and gather the data that you would need now to make the assessment as to whether that's going to be reasonable for your company or whether it would be an undue hardship. Make sure that your ADA accommodation process is up to date and that employees know about it. It should be in your employee handbook and clearly spelled out. You don't want to be in a situation where an employee needs an accommodation, but they don't know how to request it or they go to the wrong person to request it. You should make sure that your medical forms are up to date so that if an employee requests an accommodation, you can give them a form to fill out. And that's a great way to kick off the interactive process because it gives you some background information before you even step into that meeting with the employee. And then lastly, make sure that your managers and supervisors are trained on the importance of all of this and make sure that they are funneling the requests to the proper people, whether that's HR or whether it's a leadership team. You want to make sure the proper people are dealing with these accommodation requests. And you want to make sure that your managers and supervisors know that there are limitations on the types of questions that they can ask and that it's a sensitive topic. Next slide, please. So since COVID has been around for about 18 months, 2 years now, we're starting to see some cases of long COVID trickle into the court system. So we're going to go over a couple. The first one is this Edelman case, which was filed in the Eastern District of New York in June of this year. In this case, a general contractor worked for a health company. He contracted COVID-19 and was admitted to the hospital for 2 weeks. His employer texted him while he was in the hospital that he was being temporarily laid off. He was eventually discharged from the hospital, but continued to suffer from what he alleged were long-haul symptoms for weeks after his discharge. And his employer told him that they weren't going to bring him back. He filed a lawsuit under the ADA, claiming that the employer failed to engage in the interactive process and fired him as a result of his medical condition. And the lawsuit specifically alleges no employees engaged in any form of interactive process or cooperative dialogue to discuss possible accommodations that might have allowed Edelman to return to work then or in the future. So again, this really highlights the importance of the interactive process. This employee here had 2 claims. One was for discriminatory discharge and the other was for failure to accommodate. And the employer really would have had a great defense to the failure to accommodate portion if it had engaged in the interactive process and documented that. Interestingly, as we'll see on the next page here, the employer in this case filed a motion to dismiss somewhat recently, claiming that in May of 2020, when the employee contracted COVID, no one in the world understood COVID-19 to be anything more than a transitory, albeit serious illness, so no reasonable accommodation was required. So essentially, the employer argued, this isn't a disability, so we don't need to accommodate. That motion was granted in part and denied in part. Unfortunately, the docket entry in that case doesn't contain a written opinion by the judge, so we don't know exactly what part was granted and what part was denied. Personally, I don't think the argument written here is a meritorious one. As Antoinette discussed earlier, when you're determining whether an employee is disabled under the ADA, it needs to be an individualized assessment of that employee's limitations. You can't really make a broad assessment that this disease is never a disability because it's always a transitory illness. It really needs to be an individualized assessment of the employee's limitations. In the next case, on the next slide, we're going to talk about the Hamada case. This is a California state case that was filed in March of 2021. In this case, the plaintiff worked as a lab technician at a hospital. She contracted COVID in April of 2020 and was put on medical leave for 6 weeks. She was returned to work after several weeks, but still continued to suffer from symptoms of long COVID. So she asked around at her place of work about potentially getting on intermittent leave to accommodate her. But her HR department supposedly told her, "You better not," in reference to asking about intermittent leave. So she didn't ask for protected leave. She didn't ask for her accommodation, but she did have intermittent absences as a result of her long COVID symptoms. And those absences were treated under the company's attendance policy. So she was ultimately terminated as a result of her attendance. We think this will be the prototypical long COVID case. It's an employee who's hospitalized, has severe symptoms, but then is on the mend, has been discharged, can work in some form or fashion, but just needs an accommodation in order to fully get back to strength. This case actually settled, so we don't know how it would have ended up. Next slide, please. So just to wrap things up, a couple key takeaways. Keep an eye out for the EEO's technical assistance that should be released soon. That will give us more details on how they're treating long COVID. As discussed, they've already said that long COVID and COVID in general can be a disability depending on the individual's particular circumstances, but we expect to have more details in the technical assistance. And keep in mind that anytime you're dealing with an accommodation request, whether it's COVID, long COVID, or any type of accommodation request, really, the first thing you should be thinking about is how can I engage in the interactive process and how can I document that I've engaged in the interactive process? Because that's going to be your best defense against claims under the ADA. And with that, Dina, I'll kick it back to you.
Thank you, Alex and Antoinette.